Good morning, everyone. The House Judiciary Committee will come to order. Will the Secretary please call the roll?
Chairman Briggs.
Here.
Representatives Carroll,
Designation.
Donahue,
Designation.
Hanbidge,
Designation.
Hohenstein.
Here.
Howard.
Here.
Kenyatta.
Here.
Kincaid. Mays.
Designation.
Miller.
Designate.
Piele.
Designation.
Rabb. Sanchez. Schusterman.
Designation.
Chairman Kaufman.
Here.
Representatives Bonner. Borowitz. Ecker.
Designation.
Ham.
Designation.
Kale.
Designation.
Kerwin.
Designation.
Clunk.
Designation.
Kuzma.
Designation.
Ledbetter.
Designation.
Rigby. Shalaba. Mr. Chairman, a quorum is present.
Thank you. Having a quorum, we will proceed with today's agenda. First up will be Senate Bill 649 by Senators Pennycook and Kane. I don't see Senator Pennycook or Kane here. Oh, I'm sorry. I kept looking over there. Sorry, Tracy. Senator, you're in order. If you'd like to give a brief comment on the bill, and then Council Vitale can provide any additional information.
Great.
Senator Pennycook, you're in order.
Thank you, Chairman Briggs, Chairman Kaufman, and the members of the House Judiciary Committee. Artificial intelligence is transforming the way we live, work, and communicate. But like any new technology, it needs some common sense guardrails to protect people from abuse. One of the most troubling misuses of AI is the creation of malicious deepfakes, hyper-realistic images, videos, or audio clips that show events or words that never really happened in reality. A quick internet search will reveal countless real-life stories of people whose lives and reputations were upended by these fakes, but convincing forgeries, often with no legal remedy. And it's time to call it what they are, digital forgeries. This bill will build on Pennsylvania's existing forgery statutes to address this modern threat. Under Senate Bill 649, anyone who creates and distributes a deepfake of a real person with the intent to defraud or injure will face penalties. If a person created and posted a malicious, damaging deepfake video of someone online meant to hurt their reputation or damage their public persona. Importantly, this legislation balances accountability with strong protections for free speech in the First Amendment. I want to thank my co-prime sponsor, Senator Kane, the committee staff, and all the stakeholders who helped shape this responsible bipartisan approach. Thank you, Chairman, for your consideration.
Thank you, Senator. Council, anything to add to the description?
Yes, Mr. Chairman. A person is guilty of digital forgery if with the intent to defraud or injure, or with knowledge and intent the person is facilitating a fraud or injury. The person generates or creates and distributes a forged digital likeness as genuine, and 2, knows or reasonably should know the visual representation or audio recording is a forged digital likeness. A violation of this section is a misdemeanor of the first degree unless the violation was committed through involvement in a scheme to defraud, coerce, or commit theft of monetary assets or property, in which case it's a felony of the third degree. There are exceptions for constitutionally protected activity, law enforcement, developers of technology and services or systems that provide access to the internet. The bill passed the Senate 50-0. The bill takes effect in 60 days and there are no amendments.
Thank you, Council. The question is, will the committee report the bill, Senate Bill 649? Are there any comments on the bill? Representative Miller, on the bill, you're in order.
Thank you, Mr. Chair. Just a couple questions. Knows or reasonably should have known the visual representation is a forged digital likeness. How would you know? How would you know?
You'd have to look at the metadata.
So the idea is that an individual posting something will find the metadata to an image.
No, this is going after the individual that's posting this information. So say I post a photo of you on the internet knowing that it's not really you and it is in fact a misrepresentation of you, and you say, whoa, 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 that's not me. I've intentionally tried to hurt you by posting this image. You would have to go and say, hey, if you want to, this is not me. They would look and say, the metadata shows that it's artificially produced.
I apologize. So the target of the forged image would have to find the metadata?
You would have to say, this is a forged image of me. Law enforcement, it's very easy for them to say, this is a forgery. The platforms, social media platforms, they can also identify it as well.
I have no doubt that law enforcement may be able to find information. What I'm interested about, though, is whether or not a poster would be able to find the information. So if a poster, a person who took the image and then posted it as well. So if I posted a forged image under this and it's reposted 20 times, there's liability attached to each of those individuals?
The liability would be with the person who initially posted that digital forgery.
Okay.
The
And
person who had malicious intent. So if
in the creation or the posting?
in the original posting, I take that image of you and I digitally dress it up, do whatever, and I maliciously post it, I'm liable.
Thank you.
Thank you.
Thank you, Representative. Any other comments? Representative Kincaid.
Thank you, Mr. Chairman. To Representative Miller's point, I do think there's maybe some ambiguity in the language about who it's sort of targeting. I think there is some concern that that anyone who posts it would be open to prosecution under this. So I think maybe it would be good to just drill down a little bit, make it a little bit more specific. But my question is actually there, under how this is written, in particular the part where its involvement in a scheme to defraud, coerce, or commit theft of monetary assets. There isn't any provision that seems to protect the actual person who was whose image was used. In the sense of this, the way that I'm reading this looks like it's defraud, coerce, or commit theft for like a third party is what triggers it. And I don't think that there's enough protection of the actual person whose whose image is actually being used in a fraudulent manner. And I would love to work with you to try and give some additional protections to those folks that if their image is being used against their will in this capacity.
So we have passed a law in Pennsylvania requiring those images to be taken down, but the federal government has also done that. And we've been really successful working with those social media companies to take stuff down immediately. I'm actually impressed by that they are so willing to take stuff down, even if it's marginally questionable. They will take it down. That's protected under the federal government at this point. But I'm happy to work with you if you think there's more things we can do to protect the victims.
Yeah, I'm happy to support this coming out of committee, but I would love to work with you on an amendment to just strengthen language to protect the folks whose actual image is being used.
Sure.
Thank you.
Thank you, Representative. Any other comments on the bill? Representative Rabb, you are in order on the bill.
Thank you, Mr. Chair. What if the creator was an employee? The creator of the AI image that was deceptive, but the creator, him or herself, did not know that they were just doing a job for some political outfit or some individual, they were doing it at the behest of someone else. They were not aware of what is, they were just doing their job, so to speak.
So if they're just doing their job, they're just doing their job. If they're making the image, that's where the problem lies, is the person making the image.
Well, I guess that's what I'm saying. Folks who want to do this type of work, they hire people to do it. They're not generally doing it themselves. It could be an entity, a political entity, could be an individual that wants an image or video to be manufactured to produce, political damage or what have you, but the person actually doing it may not be aware of the deception, is just doing their job as a technologist, as a digital creator. Is there room or distinction between the creator and someone who is employed by the person who seeks to create deceptive images? Because that's significant. If you're an employee, you may not want to tell your boss, I refuse to do that. You're in a difficult situation, I would imagine.
I would have to check with my ledge director, but I actually think it's the person who says, hey, I need you to create this fake image for political gain. If you're an employee and you're just doing your job, I don't, but at the same time, why would you be putting a deep fake out? Well, never mind, it's politics. Of course you'd be putting out a deep fake. The person who wants that image, if you're just uploading an image on the internet, you're doing your job. But if you're creating that content and you're creating that deep fake, that's your issue.
Okay, I guess what I'm speaking of is it's not necessarily malicious intent of an employee who's,
No.
right.
But if you're the boss and you're
Right.
wanting to
Right.
create a deep fake or a likeness or a video or an audio, then yeah, you're the guy. You're the guy that's going to be charged.
Thank you.
Thank you, Representative Rabb. Any other comments before? I think we should do a roll call in this. I'm sorry. Yep. Representative Miller for the second time.
The defraud aspect of your language, I understand. It's the injure anyone that I perhaps can use some clarification on. When you mean injure anyone, can you tell me what you're trying to get at? Page 1 of your bill, line 10.
It's a comprehensive financial or reputational harm.
Okay, reputation. If a person were, are you under the belief that you would be providing the same type of First Amendment protection for somebody's text post as compared to a visual post?
Yes.
Okay. So if someone were to call a politician like a criminal or some type of shyster of public dollars, right?
Well, that's
And
not
then-
a deep fake.
I'm sorry?
That's not a digital forgery or a deep fake. That's an opinion.
Okay. Is there a definition of deep fake that you're working off of?
It's a hyper-realistic image that shows events or words that never really happened. So when you say you decide that you want to call me whatever, well, that's your opinion, and it may be true,
Okay.
but you haven't deep faked anything.
So so using the example and going off of your definition, if I were to take, if someone were to take an image of me with a public treasury image and of me somehow taking dollars out inappropriately, right? So created an image of me going with their logic of saying that he steals from the public, that he's some type of theft, a criminal act from the public, but he creates an image of something that never happened. Would they have the right to do that image?
So the exemptions in this bill are satire, parody, commentary, criticisms, or works that relate to a matter of public interest or have political or newsworthy value.
So how would that relate to injure? So if I were to say what you just did injured me on line 1, section, on page 1,
How did
section
that injure you?
because you took my reputation and you tossed it in the gutter by saying that I somehow stole money from the public good.
I don't see the injury.
Reputation.
'Cause-
Reputation.
But you'd have to be able to prove that your reputation was damaged and that it was in fact a deep fake. That's where the burden of proof, because if you don't have a burden of proof, then everyone and their mother's going to say, well,
Right. I don't think anybody's against the burden of proof. Thank you.
Thank you. Secretary, if you could, anyone else? This has been like the old days. Secretary, please call the roll.
Chairman Briggs,
Yes.
Representatives Carroll,
Designation, yes.
Donahue,
Designation, yes.
Ambidge,
Designation, yes.
Hohenstein,
Designation, yes. Oh, he's here? I'm sorry.
Howard,
I was trying to keep the rhythm going. Sorry, Representative.
Howard,
yes.
Kenyatta, Kincaid, Mays,
Designation, yes.
Miller, Kelly,
Designation, yes.
Rab, Sanchez, Schusterman, Chairman Kaufman,
Yes.
Representatives Bonner, Borowitz, Ecker,
Designation, yes.
Ham,
Designation, yes.
Kale,
Designation, yes.
Kerwin,
Designation, yes.
Clunk, Kuzma,
Designation, yes.
Ledbetter,
Designation, yes.
Rigby, Shalaba. This bill passes a vote of 25 to 1.
Great, thank you and congratulations, Senator. Senate Bill 649 passes and will be reported as committed. Thank you for your time. Next on the agenda will be House Bill 18 by Representative Alzheimer. The chair will recognize the representative for some remarks on his bill when he's prepared, and then go to council. Representative Alzheimer, you're in order when you're ready. Just pull the mic a little bit closer and make sure the green button's on. Thank you.
Thank you, Chairman Briggs, Chairman Kaufman, members of the committee. This bill is deeply personal to me. It stems from a tragic and frustrating experience for a person very close to me. About 6 years ago, if not more, this person was diagnosed with dementia. As the disease progressed, he became withdrawn, increasingly difficult to reach, and hard to communicate with. Signs we know are consistent with the progression of dementia, and folks with Alzheimer's as well experience that. Family support for individuals with dementia is crucial for both the person with the disease and their caregivers. Concerned loved ones tried to assist with getting better treatment, to get answers, and to ensure the loved one's safety and dignity. Things reached a crisis point when this person was hospitalized. At that point, family members sought legal help to get information and provide better care. They weren't asking to take anything away. They simply petitioned for shared guardianship. But that petition, an urgent plea to be involved in the care of a vulnerable person we loved, was rescheduled, and approval of additional continuations left the family relationship and the dynamic of that family destroyed. Time passed, and additional petitions were filed in attempt to ensure the loved one's safety and dignity. Unfortunately, their family member passed away before their voice could be heard. This bill is about one thing: making sure that when red flags go up, when concerned family members come forward with legitimate concerns about the care and well-being of a loved one, the legal system is responsive. HB 18 creates a clearer, more accessible process for review hearings. It ensures that families aren't shut out indefinitely and that courts have tools and direction they need to evaluate whether guardianship arrangements can continue to serve the best interests of the incapacitated person. This legislation is not about blame. It's about balance. It protects the rights of the incapacitated, respects the courts, and gives families a pathway to help when help is desperately needed. Thank you.
Thank you, Representative Alsummer. Council, please provide any additional description of the bill.
Mr. Chairman, House Bill 18 amends Title 20 to require a court to schedule a review hearing for guardianship termination or modification within 30 days of receiving the petition. The bill takes effect in 60 days, and there's one amendment.
Thank you, Council. The chair is in possession of Amendment 00770, introduced by Chairman Kaufman. Please provide a brief description of the amendment. Thank you,
Mr.
Council.
Chairman, the amendment requires the court to schedule a review hearing within 30 days of the filing of the petition to terminate or modify the guardianship, and the review hearing shall occur no later than 60 days after the filing of the petition. The amendment allows the court to continue cases beyond 60 days if absolutely necessary. The amendment also allows the court to address serial filers who file without any new issues or facts for the court to consider within 180 days. Thank you, Mr. Chairman.
Thank you, Council. The committee, the question is, will the committee agree to the amendment? On that question, are there any comments or questions on the amendment? Are there any negative votes on the amendment? Seeing none, if the secretary could please record it as passing unanimous. On that question, I'm sorry. Will the committee report the bill as amended? This new script, I love it. On that question, is there any comments or questions on the bill as amended? I just want to thank Representative Alsummer for his work on this and Chairman Kaufman and his staff. When you first came to us, we had some work to do, and the amendment, I think, accomplishes some concerns folks brought to our attention, and I want to thank you for championing this. Seeing no other comments or questions, are there any negative votes on the bill as amended? If the secretary could please record it as unanimous vote, thank you. We will report the bill as amended to the floor. Thank you, Representative.
Thank you very much, Mr. Chairman. Thank you very much, members.
Next on the agenda is House Bill 956 by Representatives Kenyatta and Flick. I will give the floor to Representative Kenyatta. I don't see Representative Flick here, but if he appears, he can add some comments as well. Representative Kenyatta, you are in order.
Thank you, Mr. Chairman. I'll be very brief. We debated this for quite some time at the previous hearing, and the premise of this remains simple. We should be saying to all workers, particularly folks that serve the public, that we're going to do everything we can to have their back and ensure that if they are harmed while doing their duties, that the folks who engaged in those attacks are going to be held accountable to the fullest extent of the law. Over the years, we've added in individual job descriptions one at a time, but there are so many workers, municipal workers, who are not currently included. We have an opportunity to rectify that and to make sure that the same protections that we receive as members of this body who are explicitly included in this, that we have those same protections for the crossing guards that we had here last time and others who've been harmed. So thank you, Mr. Chairman, for bringing this back up.
Thank you, Representative. Anything to add to that, Council?
Mr. Chairman, House Bill 956 amends Title 18, Section 2702C by adding counties, cities, boroughs, towns, townships, home rule municipalities, optional plan municipalities, or optional charter municipalities to the list of enumerated persons in the aggravated assault statute. The bill takes effect in 60 days. There is one amendment.
Thank you, Council. The chair is in possession of Amendment 00954, introduced by myself. Council, please provide a brief description of the amendment.
Mr. Chairman, the amendment adds municipal authorities to the bill.
Thank you. Council, is there any comments on the amendment before we go to Chairman Kaufman and the vote? Chairman Kaufman, you're in order on the amendment.
Thank you, Mr. Chairman. While I still have some concerns regarding this legislation in a spirit of bipartisanship, I'm going to be supporting the amendment and the legislation to move through the committee process. Thank you, Mr. Chairman.
Thank you, Chairman, for that level of bipartisanness that we have been striving for. Secretary, please do a roll call on Amendment 00954.
Chairman Briggs,
Yes.
Representatives Carroll,
Designation yes.
Donahue,
Designation yes.
Hanbidge,
Designation yes.
Hohenstein,
You moved.
Howard.
Oh, no, you're still there. Oh, you're over here. I keep looking. It's an empty seat on the screen. I'm sorry. Sorry. Howard.
Howard. Yes. Kenyatta. Kincaid. Mays.
Designation yes.
Miller. Pielli.
Designation yes.
Rab. Sanchez. Schusterman. Chairman Kaufman.
Yes.
Representatives Bonner. Borwitz. Ecker.
Designation yes.
Ham.
No.
Kale.
Designation yes.
Kerwin.
Designation yes.
Clunk. Kuzma.
Designation yes.
Ledbetter.
Designation yes.
Rigby. Shalaba. This amendment passes a vote of 24-2.
Thank you. Amendment passes, and the question recurs, will the committee report the bill as amended? On that question, the chair will recognize anyone who has additional comments on the bill. Any comments on the bill as amended? Representative Kincaid, you are in order.
Thank you, Mr. Chairman. I renew my objections to this bill. We continue to tell workers that we are protecting them in a way that does not actually protect them. No one knows what the punishment for any offense is. Assault is already unlawful, and yet if our workers are being assaulted, it is not a deterrent that it is unlawful, and so what the penalty is doesn't make a difference. We should be focusing our effort and our time on prevention, on actually protecting workers from initial harm. And I cannot, in good conscience, lie to workers to tell them that this will protect them. We as legislators are in this as well, and the simple fact of the matter is that this statute doesn't protect us either, merely because we are in the statute. We have Capitol Police here in the building. We have Sergeant at Arms on the floor of the House. And fundamentally, I am safer in my home because I have a Ring doorbell camera and a dog than because I am in this statute. I don't believe that anyone should be facing 20 years in prison for slapping somebody, which is what a simple assault is. What this does is takes a simple assault and makes it an aggravated assault. I want to protect workers, but I want to do it by actually protecting them and not by doing something that feels like we are patting ourselves on the back without actually helping anybody. So I will be a no on this legislation. Thank you.
Thank you, Representative. Any other comments on the bill before we go to a vote? Seeing none, if the secretary could please call the roll.
Chairman Briggs,
Yes.
Representatives Carroll,
Designation yes.
Donahue,
Designation yes.
Hanbidge,
Designation yes.
Hohenstein, Howard, Kenyatta, Kincaid, Mays,
Designation yes.
Miller, Pielli,
Designation yes.
Rab, Sanchez, Schusterman, Chairman Kaufman,
Yes.
Representatives Bonner, Borowitz, Ecker,
Designation yes.
Ham,
Designation no.
Kale,
Designation yes.
Kerwin,
Designation yes.
Clunk, Kuzma,
Designation yes.
Ledbetter,
Designation yes.
Rigby, Shalaba. This bill passes as amended, 22-4.
Thank you, Secretary. House Bill 956 passes and will be reported as amended. Congratulations, Representative Kenyatta. Next on the agenda is House Bill 1423 by Representative Pugh. The chair will recognize Representative Pugh for remarks on her bill, and when she concludes, council can provide any additional description of the bill. Representative Pugh, you are in order when you are ready. Thank you.
Thank you, Chairman Briggs and Chairman Kaufman, I'm sorry, I apologize for that, and members of the entire Judiciary Committee for your consideration of House Bill 1423 today. 1423 will provide the clarity on how the Office of the District Attorney is filled when there is a vacancy. In 2021, the General Assembly passed legislation to provide a uniform succession to the District Attorney's Office in 2A through 8th class counties. Specifically, a vacancy in the Office of District Attorney shall be filled by the first assistant. Although this clarified who should fill the office, courts and county officials have produced differing interpretations of how long the first district attorney shall serve. This legislation clarifies by specifying that the first assistant will fill the vacancy of district attorney for the remainder of the unexpired term. Further, to ensure that the practice is followed uniformly by all counties across the state, even those governed by home rule, HB 1423 amends Title 53 to prohibit home rule counties from enacting laws pertaining to the office of district attorney or filling vacancies of that office. This is just a piece of legislation that brings clarity to an essential office in every county across the state, the district attorney who serves as the chief law enforcement officer of the county. I would really kindly ask for your consideration of HB 1423.
Thank you, Representative. Council, anything to add?
Yes, Mr. Chairman, the bill takes effect immediately and there are no amendments.
Thank you, Council. The question is, will the committee report the bill, House Bill 1423? Are there any comments on the bill? Representative Rabb, you are in order on the bill, House Bill 1423.
Thank you, Mr. Chair. So there's a section here that removes all district attorneys from being regulated by the Home Rule Charter. So this is, make sure I have this right. Sorry, one moment. So, I want to ask you a specific question about page 2, lines 16 to 21. Thank you. So, limitation on municipal powers. There's already a current statute that prevents municipalities from legislating. What is the rationale for this section in light of current statute?
Sure. So home rule charters or home rule counties have already taken a stance, and it actually happened in our county when our district attorney went on to be actually the first president judge of our county, not female president judge of our county, and the first district attorney stood up. It ended up into a legal battle because the Home Rule Charter interpreted the law in which you all passed in 2021 differently than what it was intended to do, and that the rest of the state follows.
Just so I'm clear, if the current statute already limits that, okay. I'll waive. Thank you.
Any additional comments on the bill? Okay, thank you. I just want to add before we go to a vote, I just encourage you to continue to work with, since you mentioned your home county, all the legislators in the county regarding this. If you do have a path forward that passed today, it's going to take the support of all of your colleagues in Luzerne County. Is there any negative votes on House Bill 1423? Seeing none, congratulations. Please report House Bill 1423 is passing unanimously, Secretary, and we will report it as committed. Thank you.
Thank you very much, everybody. Have a great day.
Thank you. Next on the agenda is House Bill 1615 by Chairman Kaufman. I will be recognizing Chairman Kaufman for some remarks, and then we'll go to council before we consider a late filed amendment. Chairman Kaufman.
Thank you, Mr. Chairman. The Pennsylvania Supreme Court recently held that that it is unconstitutional for a trial court to treat a defendant's prior acceptance of ARD for DUI as a prior offense for the purpose of imposing an enhanced sentence on a subsequent DUI conviction. In light of the court's case, district attorneys across the Commonwealth have been left with little choice but to withhold ARD from first-time DUI offenders. The bill that Chairman Briggs and I have replaces ARD for DUI offenses with the DUI treatment court program. To the extent possible, our bill retains current ARD practices and provides for an automatic expungement of the participant's DUI conviction upon successful completion of the treatment program. I have to say that the process with which this bill had come about, I heard from my district attorneys. I know Chairman Briggs also heard from district attorneys in his region. And, we reached out to Chairman Briggs' office, and we have had the most collaborative, bipartisan approach. My counsel, Steve Smith, has worked diligently with Counsel Vitale, and this is what I believe is an extraordinary bipartisan bill to attempt to remedy this issue that could become a serious issue for the courts as well as first-time DUI offenders across the Commonwealth. So I appreciate Chairman Briggs and his staff and my staff working so closely together to try to come together with this language, which has been bounced back and forth many, many times, as well as the collaboration between the District Attorneys Association, who brought this issue to light, and the Office of the Attorney General, and many stakeholders. So thank you very much to all those involved in this product.
Thank you, Chairman. Council, please provide any additional description of the bill.
Mr. Chairman, the bill takes effect in 60 days, and there's one amendment.
Thank you, Council. The chair is in possession of a late filed amendment 001243 by myself and Chairman Kaufman together, which means we both agreed to bringing up this late filed amendment. Council, please provide a brief description of the amendment.
Mr. Chairman, the amendment deletes subsection E and replaces it with the current failure to comply process in the current ARD program. The amendment makes a slight change to the existing law to account for the Shiflett decision. Thank you, Mr. Chairman.
Thank you. Council, any comments on the amendment before we consider it? Representative Miller, you are in order on Amendment 1243.
Thank you. When it comes to paragraph 3 of the amendment, will not be eligible to have their criminal record expunged. Just so I understand, this is notwithstanding continued participation in the program.
Sorry, Representative, we're having a hard time hearing you.
Oh, I apologize. Yeah, sorry about that. Yeah, no problem. Hey, on this amendment, the only change was in relation to the decision. So paragraph 3 of the amendment, where it says shall not be eligible to have their criminal record expunged, that is from existing law?
Yes, Mr. Chairman.
Okay. Okay, thank you.
Any additional comments on the amendment in front of us? Are there any negative votes on the amendment? Seeing none, if the Secretary could please report Amendment 001243 as passing unanimously, I would appreciate it. The question in front of us now is, will the committee report the bill as amended? Are there any comments on the bill as amended? Representative Hohenstein, you're in order on the bill as amended.
Thank you, Chair. I very much respect both of the chairs' work on this issue and the attempt to provide the legislative direction that the Supreme Court was indicating was needed out of the Shiflett decision. I will regrettably have to be a no on this for the principal reason that the revisions we are enacting require a plea, and in most situations a guilty plea or a nolo contendere plea, which effectively operates as a guilty plea in other fora. And even though the intent is to provide this very important accelerated rehabilitative disposition process and the expungement in the criminal forum, my concern is that the pleas that are entered might be entered into with haste and without appropriate constitutional safeguards, and thus could end up impacting people in future proceedings that might be unrelated to the criminal or the DUI adjudications. So for that reason, again, respecting all of the very good and hard work that went into this, and recognizing that this bill is likely coming through and will likely go to the floor, I do regrettably have to be a no for those reasons.
Thank you, Representative. I was going to wait till the end, but maybe this will help. This was one of the challenges of the Shiflett decision, was that it is saying a guilty plea is required for the first offense to be counted for ARD. So that is, we went back and forth around different ways to do that. But today is a step. We did hear from another of folks with suggestions even as recent as like an hour ago. So I believe Chair Kaufman and I will be continuing to work on this to try to make it as good of a fix as possible. So I am strongly supportive of it, but I do understand your concerns. I mean, that was my concerns until I read the opinion like 4 times to try to figure out ways to get around it. But Representative Schusterman.
I just want to thank the chairs for bringing up this issue. Obviously, there might be changes on the floor, but I, in Chester County, heard from my DA immediately. I was sort of on speed dial about the negative consequences of the ruling. I think this is a good first step, and I look forward to seeing if it changes on the floor and moves over to the Senate as well. Thank you.
Thank you, Representative. And you were minutes behind Chairman Kaufman bringing this to my attention. So, are there any other comments on the bill as amended, Representative? Representative Miller, you are in order on the bill as amended.
Thank you, Mr. Chairman. In relation to the license revocation, what change was made from existing law to the new bill for license revocation?
Council Bat.
Thank you, Chairman. The license revocation provisions included in HB 1615 mirror the license revocation provisions in the current ARD DUI program that is provided for in Title 75, Section 3807.
So none.
Correct.
What was the change in relation to the eligibility for the program?
The eligibility requirements for the program were kept as close as possible to the current eligibility requirements for DUI ARD in Title 75, with the exception that now, as a condition of entry into the program, one does have to admit guilt, and that proceeding, the admission proceeding, then being a guilty plea proceeding would have with it the constitutional protections that the Supreme Court found were lacking in the Shiflett decision.
Besides from an ARD, and we're talking about an ARD completion, right? Somebody completed the program. So beside from someone completing the ARD program, and then subsequently in some future year, picking up another DUI, and therefore the district attorney's office seeking to count the ARD completion as a conviction. Is there any other issue that the Supreme Court raised?
Well, it's 2 issues, because in order to count in order to count as a second offense can have different gradings and different statutory maximums. Or sentencing provisions, so mandatory minimums. So this issue is really twofold. Under Lane and Apprendi, the prior needs to be a conviction in order to have these, the grading enhancements and the sentencing enhancements for the second or subsequent offense.
Okay, but it was all limited to whether or not the ARD completion would count as a prior record, for a prior record.
Correct.
Is there any other ARD completion that counts as a prior record in our state?
I think we're going to end. We did have a pre-conversation about this as a committee. That was kind of our opportunity to interrogate our own staff. So I'm going to unfortunately ask you to stop. Any other comments on comments? Representative Kincaid.
Thank you, Mr. Chairman. I appreciate this bill for trying to solve the problem of district attorneys no longer being willing to offer ARD to folks who are facing their first DUI penalty. I'll be supporting the bill, but My frustration is that we are attempting a legislative fix that really feels more like it should be a district attorney administrative fix. It turns out that you don't actually need to have the option of having an ARD count as a prior conviction in order to put someone through the program. And maybe that is the approach that we should be taking, is that if somebody goes through ARD on a first DUI, that it doesn't count as a conviction, and that if there is a subsequent DUI, that should be their first offense. It just feels like we are trying to legislate something that district attorneys should just be doing better at, and be less punitive. So I want ARD to be available to people, so I will be supporting this, but I think that this fundamentally comes down to our district attorneys really just failing to understand the purpose of shiflet, which is to say that you don't get to have a conviction with ARD, and that is the reality of things. And denying people access to ARD because you can't get a conviction is bad policy. So, thank you, Mr. Chairman.
Thank you. Any other comments on the bill? Seeing none, Secretary, please call a roll on the bill as amended.
Chairman Briggs?
Yes.
Representatives Carroll?
Designation, yes. I'm sorry. Representative.
Donahue?
Designation, yes.
Hanbidge?
Designation, yes.
Hohenstein? Howard?
Yes.
Kenyatta? Kincaid? Mays?
Designation, yes.
Miller? Yelly?
Designation, yes.
Rab? Sanchez? Schusterman? Chairman Kaufman?
Yes.
Representatives Bonner? Borowitz? Ecker?
Designation, yes.
Ham?
Designation, yes.
Kale?
Designation, yes.
Kerwin?
Designation, yes.
Clunk? Kuzma?
Designation, yes.
Ledbetter?
Designation, yes.
Rigby?
Designation, yes.
Shalaba?
Designation, yes.
Mr. Chairman, this bill passes a vote of 25 to 1.
Thank you, Secretary. House Bill 1615 passes and will be reported as amended. Congratulations, Chairman Kaufman. Last up, under any other business, I will be calling up House Bill 1629 by Representatives Kincaid and Rabb. I believe that is in everyone's packet. The chair will recognize both Representatives Kincaid and Rabb for remarks on the bill, and then we will go to the council. Representative Kincaid, you are in order.
Thank you, Mr. Chairman. This bill simply does what I advocated for in my remarks for House Bill 956, which is to create a program to prevent harm against our municipal workers who are out in public and in positions where they may be more vulnerable to assault. It requires employers to take some proactive measures, and it also establishes a grant program that hopefully we will be able to fund in this budget to allow employers to actually provide resources to protect workers who are out in the community. If I know that some of these workers have been advocating for things like body cameras, and those requests were denied largely due to budgetary reasons, and this would be a program that would allow for municipal employers, for public employers to actually provide those kinds of protections for these workers. So I would request an affirmative vote.
Thank you, Representative Kincaid. Representative Rabb, for some brief comments on the bill.
Thank you, Mr. Chairman. In brief, it may be easy for some to say why they oppose something. It's quite another to put forth a substantive solution to address the underlying concerns around violence prevention. For those of us who have concerns that there are bills and approaches that focus on things that do not actually deter the type of violence we all abhor, particularly in this moment, it's important to come up with alternatives that are meaningful to actually address these issues, and that is why we have sought to draft this legislation, and I too ask for an affirmative vote. Thank you, Mr. Chairman.
Thank you, Representative. I think we're going to go to council for a description of the bill before we go to additional comments. Council Vitale.
Mr. Chairman, House Bill 1629 amends Title 71 by adding Chapter 34. The bill requires public entities or agencies employing outdoor public workers to implement workplace violence prevention plans, create a safety team consisting of individuals who are familiar with the unique conditions, challenges, and other factors related to each unique outdoor public worker, review safety, risk, and threats periodically, and consult with employee representatives, provides training on de-escalation safety and reporting for outdoor public workers, ensures access to incident reporting systems, counseling, and legal support for threats or assaults. The bill requires PCCD, the bill gives PCCD oversight of data collection and must submit an annual report to the General Assembly, as well as creating a grant program for local government units to improve safety, infrastructure, and training for public outdoor workers. The bill also subjects employers who fail to implement this chapter to administrative fines and prohibits retaliation against employees. The bill takes effect in 180 days, and there are no amendments.
Thank you, Council. The question is, will the committee report the bill 1629? Are there any comments on the bill? Representative Kenyatta, you are in order.
Thank you so much, Mr. Chairman. And, you know, I know last week Representative Hohenstein had a bill that we advanced that was a grant program. I obviously have a lot of questions about what this would do. Of course, you know, it was just brought up under new business. I've not had a chance to review it deeply, but it is my understanding that employers, particularly municipal employers, are already doing many of the things that would be now required for them to do. And we've talked a lot about what helps keep people safe. You know, I have this crazy idea that maybe people should be held accountable for their actions, and that you don't have to assault a municipal worker, and then you would not be subject to any of the things that we talked about in the previous bill, 956. But if we're also talking about things that are useful and actually protect workers, I don't know that sending a report to the General Assembly is going to protect anybody. There's so many reports that we send that nobody in this building reads if we're being honest and candid with each other. I'm open to looking at this, learning more about it, and doing whatever we can to support municipal workers. And this bill could absolutely be a part of it. But I'm not sure, with the information that I have available to me, that this bill would actually do what I think we in this body all share a commitment to do, is to keep workers safe. So right now I'm gonna be a no, but look forward to talking more to the makers about it moving forward.
Any other comments on the bill before we go to Chairman Kaufman? Chairman Kaufman, you are in order on the bill.
Thank you, Mr. Chairman. This concept is fresh to me, and there are a lot of outstanding questions and concerns that I have regarding this legislation. I find myself agreeing with Representative Kenyatta in that respect. And at this point, I'm going to hold off any more comment and just say that today I'm not prepared to support this legislation. Thank you, Mr. Chairman.
Representative Kincaid, so it appears that will be at a tie at least. Would it be okay if we go over the bill for for today and continue to work on it? Or do you want to vote? Okay, we will run the vote. Secretary, please call the roll.
Chairman Briggs,
Yes.
Representatives Carroll, Donahue,
Designation, yes.
Hambidge,
Designation, yes.
Hohenstein, Howard,
Yes.
Kenyatta, Kincaid, Mays,
Designation, yes.
Miller, Pielli,
Designation, yes.
Rab, Sanchez, Schusterman, Chairman Kaufman,
No.
Representatives Bonner, Borowitz, Ecker,
Designation, no.
Ham,
Designation, no.
Kale,
Designation, no.
Kerwin,
Designation, no.
Clunk, Kuzma,
Designation, no.
Ledbetter,
Designation, no.
Brigby,
Designation, no.
Shalaba.
Designation, no.
This bill fails a vote.
Thank you, Secretary. House Bill 1629 does not receive the votes necessary to pass and will not be reported to the floor. Before we adjourn, I do want to thank Chairman Kaufman and his staff for the collaborative work that was put in to the previous bill. I think it is a good example of folks coming together, and I know we will continue to work together to try to get that to something that we can bring up on the floor. As a reminder, we will be having a joint public hearing with the Veterans Affairs Committee on Wednesday at 10 in this room. We are in session, I believe, at 11, so it's going to be a tight meeting to hear about veterans courts. Today's meeting stands adjourned.